Good evening, I'm Marty Owings, and this is Capital Conversations for Tuesday, February 7th, 2012.
I'm Ahndi Fridell. First tonight we are going to focus on voting issues, transparency, and data privacy issues. We will have first speak to Don Gemberling and Rich Neumeister about data privacy and transparency in government. A little later on in the program we will speak to Mike Dean from Common Cause. And it's caucus night tonight, so you may not be watching. You may be heading out to your caucus, but if you're watching the show later, we're going to get a little caucus update from political blogger and radio host Mitch Berg.
As always, we invite you to participate in our interactive weekly program here, broadcast live from the Capitol. Just drop us a message on our Facebook page at MN Capital Conversations or tweet us at MN Capital News, and you can find us there. Leave us a message. We'll talk about it on the show tonight. Okay, we're very pleased tonight to be joined on the program by two special guests. Don Gemberling has a long history with Minnesota government transparency, stretching back more than 30 years. He served as Executive Director of the Information Policy Analysis Division of the Minnesota Department of Administration for many years, and most recently as a board member for the Minnesota Coalition on Government Information, or MNCOGI as it's often referred to. Welcome, Don.
Thank you, Mitch.
Or Marty,
Marty,
whichever you prefer. And also joining us is Rich Neumeister, longtime information advocate here at the Capitol, and he also blogs about government transparency and privacy issues at opensecretsmn.blogspot.com. Thanks for being with us again.
Oh, thank you.
All right, to start out, Don, IPAD has the Information Policy Analysis Division, as Marty said, the state government agency. It has a new proposed bill that makes some technical adjustments to the current data laws, but also, can you tell us what some of those proposed changes are?
I don't know if I'd characterize them as technical.
Oh, okay.
They may characterize them that way, but I don't necessarily agree. And their proposal's in flux.
Okay.
So what was there a couple of weeks ago may not be there now. The things that we've looked at that we've had concerns about, there seems to be some kind of attempt to, the rationale for much of what they do is to promote clarity and understanding of the Data Practices Act. And so some of the things they're doing are moving things that are in some administrative rules that were actually promulgated more than 30 years ago into the statute itself. I have some understanding of why they're doing that, but the most common complaint about the Data Practices Act is it's physically too big. It's over 100 pages. And it's very unlike other freedom of information statutes in the world, actually. And I'm not quite sure what moving more into the statute does to make it shorter. Particularly when the rules are there, they have the force and effect of law. We certainly used to train people; they were there. And the other part of that is that when they move things into the rules, they haven't necessarily moved the entire rule, so they've left stuff out. And I'm not sure if that's by intent, because sometimes what they've left out is kind of critical.
What's an example of that, Don?
There's a rule about summary data. Summary data is a term of art in the Data Practices Act. It was put in there originally so that if researchers wanted to look at private and confidential data, which they obviously can't, they would have a way to seek that the data be summarized, and in some cases actually get access to the data to summarize it themselves.
In like a redacted form or whatever?
Well, it's not so much redacted. What it is it's taken out personal identifiers.
I see.
And the objective being to let research happen. And again, that's been on the books. Well, when they transfer that rule, which has all of the detail in it, there's a part of the rule that defines what summary data means, and it defines it pretty broadly. And that was done for a reason. They don't transfer that part of the rule. And that rule has been used by people to get access to data, and it would seem to me if it no longer exists, then that will be a problem.
So what you're saying is less access?
I would think so.
Potentially.
Yeah.
Okay.
And I'm not sure exactly why, if your intent is to move the rule in, why you don't move the whole rule. So I have a fondness for those rules because I spent 3 years of my life on them.
Right.
Can I just
So-
make a real quick comment on,
Sure.
on some of the things? I think Mr. Gemberling is right. When agencies come out and say, hey, we have a bill, it's just to clarify, it's just a technical bill, that's not always the case, as I've learned over my years of looking at some of the detail of this. And so this particular bill, iPads bill, first of all, it was promoted as a reform effort to save money, do all that, and all of a sudden it's changed to where it's for readability and clarity and all that, and a better understanding. But if you look into their technical things, I'll just give you 2 or 3 examples
Right, yeah.
that have impact on privacy rights, which the Data Practices Act helps with, because it's also a privacy protection for people to get access to their own data, and also to get to access to data. One of the key things that is considered as a mandate here for all government entities, local, counties, and all that, is that every year, August 1st, they have to update if there's any changes in laws or whatever. So there's a mandate to make sure it's done. They're proposing to take that out, which then means that government entities are not obligated necessarily to update the kinds of changes or even some of the changes that they may do at a local level.
And what they argue, it's too
What-
costly, Rich, or what's the story?
Well, that's one of the things, but it's not a costly issue. I mean, it's, again, I go back to what their intent was, and now it's for clarity and readability and all that sort of stuff. Another item is that there are many people who fight agencies to get for their due process. As many of your viewers may know, government has a lot of information on us. They also license us. They do a lot of things that if we are to participate in our society, government monitors things, whatever, regulates things. Sometimes, that, particularly with the Department of Human Services, right now it's very clear that if I want to challenge, not challenge, but if there's an issue about about information about me.
No, get rich, it goes beyond that. This is a fight about licensure.
No, okay, it's
Okay.
more, it's yeah, but
It's due process and licensure.
due process.
Yeah.
That's why, in other words, to assert your due process rights, you can basically ask for your own information
Right.
under the law, but they want to slip in a legal term in there that sort of will make it harder for people, unless maybe they have a lawyer, to do it to rules of discovery, which is a legal term. And some of the other things to where I don't know where they're at on this, because on the most recent summary I haven't seen it, but very controversial ones about where if you want to get access to public data, that if you have seen that data previously within a length of time, that you cannot see it again for another 6 months. And then, I mean, there's little nuggets of that as they promote it as clarifying, technical, but in the real scheme of things, it brunts up against our privacy rights and our public right to know.
They might seem innocuous, but these changes slowly erode our fundamental rights to due process, as you mentioned. Well, we'll get to that, Rich, but we do have a couple questions on there, so I want to ask you this. Talk about the Data Practices Act and what it allows or covers. How does it help the press? How does it help individual citizens?
Well, I think from the experience on 2 things. You got to remember that government collects information about us that's considered private in many ways,
Yeah, what you mentioned.
but also public. And what the data practices allow us to do is for public accountability, to be able to see how government is doing things, whether it be for budget information, memos, how much is spent. I mean, go on, but that's generally a lot of things what people do. But also when government collects information on us that may be private or confidential in some of the things to grant a professional license, like today for 4 hours, some of your viewers may have read about the Star Tribune article that talked about how malpractice things and various things are not public at the Board of Medical Practices. Well, I took 4 hours today to go to almost every licensing board, health licensing board in the building where they're at, and to try and see what's public, what's not, or whatever. Again, the essence of the act and why it's important for people to use that, media or citizens or whatever, is to be able to find out what their government is doing, either about them, relating to them,
Personally,
or in general, for public accountability. Right to know, that's the big issue.
One of the issues that lurking probably isn't the right word, but one of the discussions I've had with iPad is, Are you doing things to move things forward, improving public access, improving accountability, improving rights of subjects of data, that kind of thing? And we don't ever seem to get there. An example, one of the things the transparency community really wants is more stuff on websites.
Right,
Well,
easier access for some.
Which,
yeah.
easier access for some, yeah. And they don't deal with issues like that, okay? And somebody has to come forward and talk to the folks who sit behind us about what's necessary to get that kind of thing done. And the standard response is we don't have enough resource. Well, then we have to decide what our priorities are and what really is important. Because, for example, for 3 or 4 years now, people have been trying to get state contracts online. And at some point, the legislature actually came up with the money to do a better job of doing that, because they decided the public really ought to be able to look at what contracts are about, who's getting them, how much they're costing us, those kinds of things. So I think at kind of a philosophical level, part of this is about, are you, as a policy group, coming up with ideas to make things better, make government more accountable, that sort of thing. So.
One of the things, Don, that I wanted to ask you, since you left state government, when did you retire from your position?
2004.
Okay, 2004. The Center for Public Integrity will be coming out in about a month with this state-by-state comparison, and it was a report that I worked on, and one of the issues, it was a government accountability, looking at lots of different areas of state government, but one of the issues was the Data Practices Act, Freedom of Information.
I think your mic is half.
Am I good? Sorry. Freedom of Information laws in Minnesota, and Minnesota doesn't always come out as one of the better states, although it has been seen as model legislation. What has been different since you left your position? How have you seen Minnesota's Data Practices Act change?
Actually, if you look at it objectively, and that's one of the difficult issues here, is Minnesota really is near the top of the list of states that provide really good public access to information, okay? Now, the problem is we do it in a way that nobody else does it, okay? As opposed to having broad exemptions to the concept that all government information ought to be public, we use specific classifications of data. The practical effect is most states have a statute that's maybe at 20 pages long. Ours is over 120 pages long. But if you step back and say, is the public getting more here than they would anywhere else? The answer is generally yes. I'll give you the biggest.
But do you have to know what to look for? Or
It isn't so much you have to know what to look for. It always helps if you understand the basic mechanics of how the statute works. The best example I can give you is virtually every place in the country, except us, have an exemption for something called deliberative process. And what that means in English is what the government writes down when it's trying to reach a decision. The federal government loves deliberative process as an exemption. And you can't get at that. Minnesota does not have a deliberative process exemption. The closest thing we have to it is something that deals with the governor's legislative proposals. But if you go to a city council in Minnesota and you say, I want to see all of the detail that you looked at in reaching a decision, in most cases that information is public. So why you decided to bring this company in to do a development in your city, all of the correspondence that went back and forth, what the recommendations of the city planner were, what the development people were offering them by way of enticement, that's all public. Other places it might not be. That's the best example I can give you.
I just want to hit on two others. Also, there's what they call warrantless invasion of privacy is another broad exemption. So things that would be public here, the public is involved in deciding what should be public, what should not be public, along with the legislature. But they have broad exemptions, like it's an invasion of privacy, and things that would be public here would not be public in a great many other states because of that broad invasion of privacy. Second item. One of the things that the public is very much interested to know, particularly in cities and urban areas and outstate areas too, in cities, what are the city fathers and mothers and the planners coming down with the budget maybe 3 months before the mayor or the county board exec announces their budget.
Right.
Well, all that stuff is public. In almost every other state that I've looked at,
Well,
that kind of information is not
that's
public.
fine, but this isn't a show about what works in Minnesota. It's about, we're talking about the erosion. We had, the show was going to be about,
I agree
let's talk
with
about
erosion.
what's changed.
No, I'm just trying to illustrate the example to
I
Ms.
know there's
Fridell's
a lot of
question.
good things about Minnesota, but if we're going to be the gold standard and hold ourselves to that with open meeting laws and data, there's been a slide, and you guys talk about it. You talked about it, Rich, with these classifications of data, and I want to bring it up and challenge you on that, because there's what's considered confidential data, and then now there's this new proposal to add intelligence data, which is a different, as you mentioned, Don, a classification of information or data.
Well, intelligence data would be a type of data that law enforcement wants classified as confidential.
Right. So can you talk about that, Rich and Don? What are things the public isn't seeing or doesn't have enough exposure to that could threaten their due process or right to this information?
Well, I'll just say at least a couple things, and then maybe Don can expand a little bit more. For me, for a great number of years, and there's a lot of stuff that is public information, what police do, that is not generally public in other places, but here is greatly public. One of the fears I have is with this new proposed possible classification, information that is now currently public will no longer be public. And again, there hasn't been a bill yet. There was a bill 3 years ago that was proposed, but there were a lot of questions about First Amendment, how it compromises First Amendment rights, making things that are currently public for 30 plus years no longer public. What does that do with the accountability and the right to know?
The erosion you mentioned is in situations where the government gets real creative about using one of the existing classifications to apply it to things that it was never intended to cover. And the growth area, as it were, is in something called security information. And here's an example. When people went to state government during the shutdown and said, we want the names of people who are working, who didn't have to go on layoff, they were told they could not have the names of people who were working because it's security information. Now, there's a whole section of the Data Practices Act that deals with data about employees, and under that section, the fact that you're working is public, okay? But somebody in the Dayton administration decided they would apply the security information classification and said to the public, you can have access to that. Now, their rationale was, you cannot.
You cannot, okay.
Their rationale was, if people found out who was working and they weren't, they might get upset and do something to them. Well, I would submit to you, the day you came back to work, you know who worked, okay?
And of course, there's laws if you do something to
Exactly,
them, right?
yeah. And if you were really that, I'll use the word crazy, all you had to do was sit outside the building and see who came and went in the building.
Sure.
I mean,
Right.
the streets weren't shut down. So another example of that is the law enforcement is now, there's a section of the Data Practices Act that spells out very clearly what information about law enforcement activities is public. It was one of the great compromises in building the Data Practices Act. Law enforcement is now beginning to say some just ordinary things that used to be public. They're calling security information and therefore rendering them not public. So, for example, if somebody at the Mega Mall,
Like Patriot Act stuff?
well, no, this is our law. This isn't Patriot.
Okay.
If some store at the Mega Mall says there's some suspicious people hanging around my store, I want the Bloomington Police Department to come and check it out. In the Data Practices Act, the fact that that call was made and the fact that the cops responded to that call would be public information. The Bloomington Police Department is now calling it security information and is treating it as not public information.
But this creep sort of stems from what's been done at the federal level, isn't it, with Patriot Act?
I think that's part of it. The federal government, at least if you watch representatives of the federal government come here and talk, including the FBI, the U.S. Attorney's Office, they do not like our Data Practices Act. They don't like it at all because too much is public. The worst example that they would give you is, in Minnesota, if the government's keeping information about me, no matter how it's classified, even if it's confidential, I have a right under the Data Practices Act to at least find out that the government has got the data. Now, I can't see it, but I can find out it's there.
They don't even want you to know it's
And they
there.
don't even want you to know it's there.
No.
Exactly.
Can I just, one other quick, it was on, another example of security information is the issue of Planned Parenthood, which is being built here
Oh.
in St. Paul, which I think, some of the stuff I can see being security information, but to where you want to know who's building the building by permits, and they say that security information is bogus. But from my point of view, particularly when
Right.
they say it's documented threats against these people, and then you ask and look at the files, there's no documentation. Again, so it's in the general thing of how, one of the things about what's happening is security information, that's one of the erosions. But also, I want to further on to your question is the issue of enforcement. What's happening is government is starting to have a little bit more moxie and saying, how can I say it politely? Boulder dash you, how's that? You know, or something
Right.
too. Putting blocks, roadblocks, and there's not an option. And so that in its own way is an erosion. So when we're talking about earlier about what iPad can do and all that, is take some leadership, the governor's office, working with the legislature or whatever, to take a look at a better way of enforcing rather than go to court.
We only have a moment or two left, but we should mention too, Ahndi, that this is nonpartisan in nature. I mean, it's just about information, and both the left and the right and those in the middle want to know this stuff. And if these erosions continue, guess what? The government can collect information on you all they want. You'll never know about it. And
Well, and whoever's in power wants to keep the information, right? Isn't
Well,
that the way it
and,
is?
you know, the best example of that is when the Obama administration was elected, the Freedom of Information community just went berserk with joy that things were going to get better. And guess what? They're not better.
They've learned.
they might be, well, with the National Defense Authorization Act, they might have gotten worse. So
Now, well, you know, and the Obama administration is putting more whistleblowers in jail than the Bush administration ever did. You know, and it's like, what is this? But the nonpartisan thing, I think, is a very important point. The people that Rich and I work with in the legislature are some of the most liberal and some of the most conservative people in the legislature because they get it, okay? And I'm not always sure why they get it, but they get it, okay?
They understand it's the people's
They understand.
government.
Yeah, they understand it's the people's government. That's really good. In that, they both understand that part of what you do in a democracy is you hold the government accountable. And one of the ways you do that is getting access to information.
And I want to say more, like there's a new buzzword, transparency. And I'm starting to go away from that word because transparency is the same basic concept that I've always used for my 30 plus years. The right to know. The public has a right to know public information. That's the essence. And to me, it's a much stronger word than this word that has been a part of the you know, the lingo for the last several years.
Well, we've got to finish up, but I still wanted to ask you guys this. I guess I will. Okay, we'll go a minute or two longer.
Okay.
What about this, you know, the governor has these meetings at the end of the legislative session with the legislative leaders, all the press corps. We all camp out down there and eagerly await for them to emerge from their meeting. And we
Except
know-
when you can't get in the building.
Except when you can't get into the, and they tell us nothing about what the discussions were, none of that. And open meeting laws apparently don't apply to them when they're in those kind. And then they set up this kabuki theater called the LCPFP meetings, or the Legislative Process and Policy Committee meetings, where they basically trump out the policy talking points and then go away and don't answer questions about what is really the issue and what was really discussed. Is there any way to get more, sorry to use the word, Rich, but transparency into those workings of the government? We've all heard the excuses they use, right? If we talked about you, if we told you, the public, what we talk about, we'd be embarrassed.
Well, I'll just say directly, for the right to know. Number one is the legislature, like a great number of other states like Florida, and I think some other, I know Florida is at least one, they come under the regular freedom of information laws. They come under data practices like everybody else. They should be treated. That's number one. Number two, the legislature more than likely is not going to do that. But what the public needs to know is ask these individual representatives and senators and the governor using the Data Practices Act I want to see your working papers. I want to see your documents. Are you taping the meetings? And ask. And if they say no, the public, I went to senator or a representative who's involved in these meetings. I wanted to take a look at their working papers, their memos. How did they come up with this bill? And if they say no, publicize it on the internet, blog it, make sure the newspapers do it, who sometimes are not doing a lot of the jobs that a lot of other folks are doing, but get the media out there. I mean, that's one way is I'm sorry to say, but it's embarrassment sometimes in those situations. So that at least there's two options. One is, more direct, hey, give us the data that would be public, that should be public. The governor used the Data Practices Act, or get the folks behind us to make them come under
Do people care enough, Don Gemberling, anymore?
It's funny, I'm actually teaching a class on privacy and transparency. And today's subject was transparency.
Not at the old alma mater, William Mitchell. You're not over
No.
Okay.
This is the Osher Lifelong Learning Institute.
I got
Continuing education for geezers. And my class cares. Okay, and part of what I'm doing in my class, you wouldn't be surprised to learn, is trying to get them to care more and to do the kind of things that Rich is talking about. But the Minnesota Coalition on Government Information, our idea, and we're going to try it here somewhere in the process, is to require that those end of the session meetings be taped. And that when the budget is done, that those tapes be made available to the public. Because, that's, the legislature requires that city councils and county boards and school boards do that. So shouldn't what's good for the goose be good for the gander, if I could use an old cliche?
And on that, I think we'll wrap up the program, at least the segment.
Hey.
That's all we have time for, gentlemen. But for people who want to learn more about these issues, they can visit MNCOGI, that's MNCOGI.org, and or opensecretsmn.blogspot.com. That's opensecretmn.blogspot.com.
Or just do a Google search, Rich Neumeister's blog. It'll come up.
I think
Right to the top.
if you try to spell Nuemeister, you might better go for Open Secret MN. Thank you both for joining us.
Thank you.
If you send a question to the MNCOGI website, we'll try and answer it.
All right.
Yep.
You can also learn more about these issues and see some of these documents we've been discussing tonight at publicrecordmedia.com, and we put up some stuff on the website.
Coming up next, we will be joined by Mike Dean from Common Cause, and we have a whole host of things to talk about. We have redistricting, voter ID, we have money in politics, so stay tuned.